There we go.
All right. Well, good afternoon, everyone. As I was saying, I'm so glad for the powers of technology that even when traveling for the school, I can still be part of this wonderful time today. So, welcome to the continuation of our Race and the Law series. We began this series in the fall of 2020 with the goal to introduce and encourage substantive conversations about the ways that race and diversity intersects with our various doctrinal subjects premised on Professor Dorothy Brown's book, and I have to make a plug. I have free copies of that book in my office, and I'm happy to give a copy to anyone in our community who wants one. We've spent time exploring what have been difficult but meaningful conversations. And these are not meant to solely be lectures. What we're aiming for are discussions that spark thought and even research in our community. We do not expect our professors or any of our community members to have all of the answers, but what we do hope is that those in attendance will leave today's conversation with new perspectives, thoughts, and again, research ideas. We've had robust conversations about the intersections of race and property, criminal law, civil procedure, contracts, immigration law, and domestic violence over the past 2 years. And I'm very excited for our conversation on alternative dispute resolution and mediation with two stellar professors, Professor Stephanie Blondell and Professor Aparna Gupta, happening today. Professor Blondell is an associate professor of law and faculty director of the Strauss Institute for Dispute Resolution. Professor Blondell also directs the Strauss Mediation Clinic. She has served as the manager of various government dispute resolution programs, including the Alternative Dispute Resolution Coordinator for the City of Seattle and the Court and Program Manager for the Dispute Resolution Center of King County. She was recently awarded the Southern California Mediation Association President's Award. Professor Gupta serves as Director of External Relations for the Strauss Institute, where she implements conflict resolution programs and advances collaborations with public sector and private sector entities. In her role, she works closely with organizations to utilize dispute resolution processes to address public policy challenges. She also teaches cross-cultural conflict and dispute resolution. As I said, our conversation today is truly meant to be a dialogue, a conversation. So Professors Blondell and Gupta are going to start us off by sharing some thoughts, about 15 minutes-ish, on the framework of ADR, points around neutrality and remedies in ADR, particularly mediation. And then we want to have a conversation with all of you joining us. If you're like me and you're on Zoom, you can use the raise hand feature or the chat box. If you're in the room, raise your hand and either Professor Gupta or Blondell will call you out. And I'll have a couple of questions to get us started from there. But at this time, I'm going to turn to our two fabulous experts to talk a little bit about some theological, I'm not sorry, not theological. I've been in those meetings all day. I'm sorry. Theoretical frameworks that may be useful for us to consider around, again, alternative dispute resolution concepts and approaches and uses in things that may involve race or diversity of other forms. And so I'm going to turn to Professors Blondell and Gupta.
Although I will take that as an invitation to come, but I just taught a class in my church and we can talk about theological connections to material as well. So I am going to get us started because the way that Professor Gupta and I thought about this was to give you some language to start having a conversation with us. So what I'm going to do is do a little bit of a history of this concept of neutrality within our field. And then Professor Gupta is going to fill in talking a little bit about some of the ways that the theoreticians have talked about diversity in the field over the last 30 years as well. Okay, so we'll do that and then kind of take it from there into some of your curiosities and some of our curiosities as well. So let me just see who's in the room. So how many of you are JD students? Okay, almost all. I wasn't sure if this had been advertised for undergrad students too. Okay, so JD students, how many of you 1Ls? Okay, so then maybe we'll do a little more on the DR continuum. How many of you have already taken a mediation class? Those of you that aren't 1Ls? Okay. Okay, so then we will start talking a little bit about kind of the foundations in our field around neutrality. So two concepts I want to introduce you to. First of all, does anyone want to give me a definition of mediation? Just since there's so many else, I want to make sure. Anyone want to? Okay, that's just kind of you. What? Go ahead, tell us.
So I would say mediation is when a legal party, like maybe a retired judge or a attorney, comes in the middle of A and B, two different parties, and kind of hears both sides, and then they can make a decision after hearing it, but it's non-binding.
Okay, you've got a lot of the major elements of mediation in there. And it's important to talk about neutrality and impartiality and race as we're talking about the intersection of those concepts. I think it's important to define what mediation is, and you did it beautifully. Okay, so sometimes it's a retired judge, but sometimes it's someone like you, someone that's like Professor Gupta. It's like you. So we run a mediation clinic here, and many of you get 20 cases in on your resume in terms of mediating cases for some of the pro se litigants out at Los Angeles Superior Court. So those are the people that are showing up to a calendar and they don't have legal representation and a mediator meets them there. But what's critical about what you said is it's non-binding unless you create a contract, and then it might be enforceable. It might be enforceable, but there's not an adjudicator that comes in and creates a binding moment. So yes, go ahead.
So like, just so I'm clear, when it comes to arbitration, that is binding, right?
Yeah, arbitration
So
is
you guys
binding.
had how you guys be mediators, but when it comes to arbitration, can you, or that's like only a lawyer or a judge?
Well, I mean, we're both lawyers. It's not the arbitration, the practice of arbitration is staffed usually by lawyers and judges, but even some non-lawyer arbitrators exist in certain industries. So like lemon law, FINRA, there's a number of arbitrators that aren't lawyers either. So yeah. Okay, but what I want to talk about is so it is non-binding and it's voluntary, which means you don't have an adjudicator stepping in there. And when we think about the process of the dispute resolution, we think about like self-help here to negotiation where you have lawyer to lawyer, interaction to mediation where you have a third party stepping in to assist, might be a lawyer, might be a judge, might be a non-lawyer, to arbitration, which is a form of litigation that's private, right? It's a private form of litigation. So here you would have also a third party, but the difference between these two is this is consensual and this is adjudicative. Consensual and adjudicative. And then of course we have here, rather than the mediator being this person, this would be the jury, or if it's a bench trial, the judge. Okay, so this is actually a panel. Okay, okay. So this is where mediation sits, just as a reminder. Now, one of the things that makes mediation from its foundation is this concept that we're impartial or neutral. The ethical rules refer to it as impartiality, but our role is referred to as a neutral. People will often call us a neutral. The panels refer to themselves as panels of neutrals. And yet, what is this concept neutral? And especially when we're looking at issues where race is the issue or diversity is the issue, it becomes very, very troubling to think of being neutral, right, in certain situations. So there has been an evolution within the field. I want to talk to you about 4 different terms that I have seen over my 30-year history in this field. And the literature follows this. So from neutral to impartial, to a concept that we call multi-partiality, to a concept that I hear a lot more about now, pro-partiality. Okay, so I'm putting those all up before I talk about them, just so you can see, you see a natural evolution within that, right? And you can probably guess what some of the concepts embedded underneath that are. So this often refers to currently the role. We are neutrals, okay? But are we truly neutral? No, impossible. We could approach that from brain science, from implicit bias. We could approach that from a number of different perspectives, but we are not neutral. And there is still a remnant in the field where people think, well, you're not actually neutral, but you need to behave neutrally. So understanding the difference between those two things is still something that's taught quite a bit. Okay, I think that's a little controversial. We'll talk about why. It's actually fine to not behave neutrally when there's injustice as a mediator. I think that's a common myth, but we'll talk more about it. Impartial is the word that the code of ethics refers to. And impartial is different than neutral. Neutral says I'm Switzerland, right? And impartial is a different positionality. Impartial would say, I'm not on your side and I'm not on your side. I'm not actually occupying a space of neutrality, but I'm not partial. And that's what most of our field has relied upon in order to describe what we do, is this word impartial. Let's go to the next word here, multi-partiality. I was exposed to this term about 20 years ago. I was taking a social justice mediation training. And it was a word that the trainers used. It was the first time that I had heard it. And I have found that it is not only useful within mediating cases that have difference, or where race is the issue, where ethnicity is the issue, where difference is the issue. It's useful in just about everything that I do. And the idea here is mirroring something for those of, there's only 2 in the room who have taken a mediation class. So I'm going to very quickly put up one more little graph here, but I think it will be the most quick way to illustrate this concept so that you grok it, okay? This is something called the Thomas-Hillman assessment, and it describes it describes conflict styles, okay? And it says there are 2 axes. This is the axis by which I assert my own interests. This is the axis by which I assert the interests of others. And there are 5 words we plot on here. All of these words are words that you use in common parlance. You will know these words. They are competitive. And as you see, I'm asserting my own interests, but no one else's. My own interests only. This one down here is accommodation. Asserting the interests of others, but not my own. This right here is avoidance, because I'm not asserting mine or theirs. This one is called compromise. This is what we do in many lawsuits. It's called the traditional distributive dance. We are dividing the fixed pie, the mythical fixed pie, okay? We're distributing resources. This is very troubling when we have power at the table that is not equal or does not mirror. Distributing those resources can become very troubling for the mediator watching this play out, right? Okay, so that's compromise. And up here is something called collaboration. Collaboration, a deeply overused word. And what people are usually saying when they're talking about collaboration is they're saying, a lot of times they'll say, let's collaborate here, but what they really mean is let's cut it in half. Collaboration is something different. Collaboration is, do you see it's at the top here and at the top here? Which means I'm working for my own interests to the nines all the way, and I'm working for your interests to the nines all the way. Okay, so multi-partiality. I'm getting back to this term right here. It's super important when we're working in cases that involve difference or social justice issues. Multi-partiality says, I'm not going to be Switzerland, and I'm not going to not be for you and not be for you. Instead, I'm going to step into it more actively. And I'm going to be to the nines for this person, and I'm going to be to the nines for that person. And I'm gonna help them see that my problem is your problem. And that we will achieve more of our goals. And for many mediators who are also interested in systemic change, we will actually model the type of resolution at the table that involves systemic change. If we're more than impartial, but we're multi-partial, I'm partial towards you, I'm partial towards you, I'm gonna help you guys see each other. And I'm gonna enter in a very intimate way to help you see each other's true self. Okay, so that's multi-partial. Pro-partial is a word that I love that's been being used. Once again, I haven't seen this one written about. I've been seeing a training shop use this one or two, couple training shops who are training around social justice mediation. And the concept is, I'm going to be explicit and upfront from the get-go about what I'm pro-partial towards, which means this is an anti-racist space, perhaps. My mediation room will be a room where I don't know how many mediators are as deeply engaged enough to say, this will be a room where I'm looking at my own white supremacy and I'm bringing that to the table. But if there are issues of injustice, I'm gonna let you know up front. If there's certain language used in my mediation room, I'm pro-partial towards a certain type of X, Y, or Z, and they define that, right? So this is the trajectory that we're on. I'm not gonna speak more because I want to give the mic to Professor Gupta. Along the way, many people have talked about the flawed aspect of the mediation model, having embedded notions of whiteness in terms of the facilitated mediator model, in terms of how it's run, when it's done, the control of the mediator, the agency of the mediator, the imposition of neutrality on top of deeply troubling social justice issues. And so I'm going to let you start talking about that, and then we'll jump into more questions.
Thank you, Dr. Blondell. I always feel like it's never a bad time to get an intro to ADR. So many of the 1Ls in the room, if ADR seems like a foreign concept, it likely is, right? In most legal curriculums, ADR, dispute resolution, is not a central focus. You, my friends, are the lucky ones here at Strauss and at Pepperdine to have alternative dispute resolution, as Professor Blondell said, see litigation as one part of the adversarial system, right? See mediation, arbitration, they're all tools that you can use throughout your legal practice. You don't even have to be a mediator if you don't choose to. So I'm going to talk a little bit about I'm going to get a little bit more granular because I think what Professor Blondell has done has given us an overview. But I always like to start with having a shared foundation. And implicit bias, for those of you in the room who may not know what it is or sort of have a general idea, but maybe not the full idea, they are automatic associations of stereotypes and attitudes that we have in our brains connected to social groups in society. There's a whole host of research. You can even look at implicit bias in neuroscience. You can look at implicit bias on the ADA website or the National Institute of Health website. So this is a very studied body of science, cognitive science that exists. It is routinely cited in Supreme Court doctrine and opinions. And so I want to just put that out there for anybody who might not have an idea of what implicit bias or implicit associations are. There is a central founding institution that started this work. Of course, it's Harvard. Harvard has Project Implicit. It was started about 20 years ago by some scientists and lawyer scientists, imagine such a field, who went on and really thought to look at, how are judges making these decisions? Are these decisions, fair, right? And so the one question, of course, led to another, and now there is an implicit association test, an IAP. There's actually several different versions of it that you can take to measure not how biased you are. I don't want you to think about it as something like, oh my gosh, I'm so awful, I'm so biased. The truth is that we're all biased. We are so programmed and sort of conditioned by the society that we live in that, our brain just naturally jumps to conclusions at times. And so, I wanted to just begin with that sort of understanding. So neutrality is it's a core of mediation, right? It's who we are, we're neutrals. And there's 4 elements to mediator neutrality, right? We can think about if you're mediating a case, right? You want to make sure that there's no conflict of interest, much as the same that you do when you're litigating a case, right? You want to make sure that there's no conflict of interest. You want to make sure there's procedural equity. What you're doing with one side, you're also doing with the other side, right? You also want to make sure you have outcome neutrality, that you don't have a stake in the outcome, right? And the last element, which I think is the most important, is that there's a lack of bias, prejudice, or favoritism toward any one party. And that's really where implicit bias and mediation really connect, is this fourth element. And so, mediators, right? Any of you who take Professor Blondell's mediation class or take my cross-cultural class, you're going to get to do lots of exercises in which you are the mediator. And you are trying to persuade one party to look at the interests of another party, to drive agreement. Can there be some common shared ground? And naturally, when you're persuading, are you being neutral? No, I would argue that you're not. You're trying to practice. You can be impartial and persuade, but I think it's very hard to be neutral and do that kind of persuasive psychological work that you do with parties to help them inch towards something that resembles an agreement, right? So, this woman named Carol Izumi, she's a law professor at Hastings, and she wrote one of the seminal articles on implicit bias within mediation. So there's been a lot written about implicit bias in the legal field, but she was like, I'm actually going to look at ADR and mediation. And, what Project Implicit, it had a lot of findings, and you can Google it and find it, is that most Americans, regardless of race, have a 75% positive association towards dominant social groups, white, male, heterosexual, right? And I think this is not news to anybody in this room. But what I think happens in mediation is this in-group favoritism. It's not as much, there can be, of course, bias, but I think most mediators have this, you enter the field of peacemaking with a sense of wanting to do good. And so generally people who come in, think of themselves as unbiased actors, as neutrals, but sometimes we're not as cognizant about the in-group favoritism that we might carry with us. And so, for example, there was a study done by an institution, and it was a resume, the same resume. Top of the resume said Thomas Meyer, right? And a big group of people was told Thomas Meyer is white. And within a resume, 3 grammatical errors were found. Then a different big group of people was told Thomas Meyer is African American. Who wants to predict how many grammatical errors were found? 6. So almost double, right? And so that's the kind of in-group favoritism that often goes unnoticed. I think we're all very cognizant of when a biased interaction occurs, and in some ways they're easier to spot. You're easier to say, aha, you should not have said that. But this in-group favoritism is something that, of course, exists within courtrooms, but also exists within mediation rooms, right? So Professor Izumi, I can absolutely share her article with Dean Richards to share with you. She outlined 3 or 4 different proposals, and these are very in line with how to reduce bias and implicit bias for lawyers, right? Requiring mediators to take the IAT, right? So that they can be at least aware of the biases that they carry. As good as we are, and we think that we are, there are harmful attitudes that sometimes, we picked up in childhood or from social groups that we were a part of. And so just that awareness cures bias so easily, right? The second part is, it's not just enough to be aware, you have to actually have a plan. So not take it so harshly, like, oh man, I really messed up and I said this to this friend and now they're gonna think I'm a racist or whatever, right? But really having what she calls an implementation plan. So if I encounter this stereotype, I'm gonna tell my brain, stop, and then I'm gonna do a different behavior. And actually that has been really successful once you have the awareness factor, to then come up with an implementation plan of like, when your brain goes there, and all of our brains go there, right? There's no morality around this, to really check yourself, right? And then make a different decision. And the last thing she says is, really exposure, right? Finding counter stereotypical examples that you can by maybe co-mediating with an attorney of color or a mediator of color, right? So trying to find and get exposure to stereotypes that you may harbor, but then finding, you know, basically folks that break that stereotype. And so those are three small things that she mentions in her article as like places where interventions can happen on implicit bias and mediation. And we see that happening. It's not a perfect field. There is a significant lack of diversity in mediators. In some ways, you know, that aligns with the law, although I would say actually the ADR field is not as diverse as the legal field. And so one big sort of critique of mediation in ADR I wanted to mention is a scholar named Richard Delgado. He's actually a critical race scholar. He's still there at the University of Alabama. And, you know, he had two critiques of ADR when it came to disadvantaged groups and serving disadvantaged groups. And he said, look, you know, we are all really prejudiced. And he said this in the 80s, right? Like not like right now, this is like 50 years ago. And when we are so prejudiced, we can't send disadvantaged parties into the black box of mediation, private, right? Binding at times, because those prejudices inevitably will disadvantage, you know, disenfranchised communities of color. And this was in the 80s when there was a lot of litigation and the courts were a venue for remedies for communities of color. He also said, you know, at that time, there was a lot of litigation in the courts. The courts are really active in protecting the rights of folks. And so he said that, you know, pro-rights groups or sort of cases where, you know, people's rights are at stake, those are better solved in litigation. Those commitments are more durable, decisions are more durable. There are procedural safeguards in place, right? There's jury selection, there's the types of evidence that can be brought in. And so those are two places that he thought, you know, ADR is not a great mechanism for communities of color to seek relief on the issues of, you know, rights when it concerns, you know, race and national origins. So I just wanted to, you know, pick your brain and sort of see sort of what resonated in what Mr. Blondell and I said, and see if you have any thoughts to share.
Yeah, so
Let's let Dean Richards jump in and.
well, I was just going to say thank you both so much for that. I feel like I even learned so much. Full disclosure to the students in the room, I signed up for the Strauss certificate and then was doing way too much in law school. So literally never took a class in mediation or ADR, but find it so fascinating because, as I'm sure either of these wonderful professionals will tell you, something like 80 or 90% of cases that go through litigation don't end up being resolved in the court system. So we have to think about these other places where things like bias and stereotypes may come into play and impact our rights. Okay, we want this to be a conversation. I have a few questions to kick it off that I previously shared with Professor Blondell and Professor Gupta, so they will sound exceptionally well prepared. Although I have more that sort of percolated from some of the things they were telling you. But I also recognize that some of you in the room may have questions, may have thoughts as well. So I'm going to ask them to be the eyes on the ground if anyone, or perhaps Kristen in the back, if anyone does raise a question. One that I have is we talked about like neutrality, and I was really fascinated, Professor Blondell, with your comments on multi-partiality versus pro-partiality. And I'm wondering how that works when there are cases, and Professor Gupta, you touched on this a little bit, but where there are cases where one party is coming in because of the belief that discrimination of some sort has occurred. So to give a little context for the students, the law school and the Strauss Institute recently partnered with the City of Los Angeles Department of Civil Human Rights and Equity to provide mediation in civil cases where discrimination is alleged. So that might be in workplace, that might be in housing, etc. And I'm wondering, when you think about partiality or neutrality, how that works when someone is coming in saying, my rights were violated, and what it looks like to, if we're thinking about your spectrum there to the nines and to the nines, have a party think about advocating for themselves fully when they're alleging discrimination. I don't know if the question made full sense pulling that together.
Can I tell a story?
Of course.
A story that may or may not answer it, but it's just like this was one of those cases that I think in my first 10 years of being a mediator, I'll just never forget it, because I think illustrates the tensions that you're asking about, inherent in your question, demetrics are tensions, right? And I will just go, I just want to start out by saying, the beginning of my career, ADR was often seen as an access to justice issue. Like, this will help access to justice. I hate that. I mean, to me, if we cannot figure out how to help people access to justice, we have a problem with our advocacy arm, right? So I do not think ADR is a substitute, but what it does do is it sometimes in the discrimination context provides self-determination for the parties. They may not even get an advocacy concept. So true story. This one is troubling, and I don't know I'll be able to fully unpack it. My stomach still hurts when I think about this story. I was mediating a case for a municipality. They had a discrimination ordinance. It was more protective than the EEOC. Okay, so a lot of people filed under that particular city ordinance. I had an African-American, disabled, psychiatric disability, former veteran, homeless man as a party. He did not have legal counsel. He was pro se. On the other side, I had a faith-based organization that was employing him. His medication went off, quote unquote off. So those of you that don't know, if you have a major mental illness, sometimes your medication can just go wacko, right? And so you can be in the hospital, it takes 3 or 4 days to recalibrate. That happened to him. He then called the employer and said, you know, my medication's on now. Employer knew about his disability. Okay. My medication's better now, blah, blah, blah. I'm gonna come back to work. Oh no, we've already terminated you, was the answer. Okay. So just so you know, the American with Disability Act is required to go through an iterative process if someone has a disability, and the employer is required, if they know about the disability, they did know about the disability. Okay, so fast forward, he files with this agency. He does not have legal counsel. They send the case over to someone like me to mediate. So what do you want? He says, I want $500 and I want my job back. My stomach's hurt. Your stomach should be hurt. Okay. How much is this case worth? I don't know. This was many, many years ago, maybe 30,000, maybe more. I don't know at the time. I used all the skills I could as a mediator. I probably went right up against some of our ethical lines too, because I'm not supposed to be his attorney. Well, sometimes we start with the other people starting. Do you want to wait and hear what their offer is first? No, $500 and I want my job back. Did you know there's a neighborhood legal clinic? Did you know if you waited until next Tuesday, you could go and maybe get advocacy? No, I mean, it was amazing. What do you want the money for? I could prepay for the shelter for a year. Yeah. Do you, okay, I'm all for informed decision-making, and that's part of my job. I need to make sure that these are durable, lasting agreements, and that at the end of the day, if people settle, they're happy about the settlement. If you were to find out your case was worth, I don't know, $30,000, that's where I'm probably up against like evaluation, ethical issues. Would it be different? No. I'd go in the other room. They're like, what does he want? He wants $500. I mean, I'm ethically required. He wants $500 and he wants his job back. And you know, they hem and haw as if that's a problem. You know, like, oh, he wants his job back. We don't normally do that. We ended up going back probably another hour or so, going back to get it done. But this is the point I want to make to you all. As we were leaving the building, I'm escorting him out. He turns around, he looks at me, he goes, yes. Right? So this man in several protected classes, disability status, ethnicity, veteran status, he was unhoused, and he went up against the man, and he won, got his job back. And he had $500 in his pocket, which is what he wanted. Now, I spend hours thinking about this case, and it's out of my job description. Like, I mean, I can, in my own sense of whiteness, think that money, or my own sense of financial privilege, think that money is something he should have. I don't know if he would have been able, if he got an apartment, could he stay in an apartment? Was he safe with the money? I don't know the answer to these questions, and really that's outside. I just did everything I could to try and give him access to advocacy within the mediation process. Because that's something I believe in very much, is that you have an advocate, and that advocate is with you in the mediation process to protect some of these rights. And when we don't have that, we have the self-determination of the parties, and it's a something. That's a really big something. I hope to this day that we have him on this planet, and I hope to this day he talks about that mediation as a win. And I don't know. That's the hard part of our job, right? I don't know. In discrimination cases, I will tell you, it's usually a pie though. There's a lot of the distributive dance, and it's about when advocates are there. Dean Richards, it's often about, it's very, I think sometimes difficult conversation for the parties at the table who've been discriminated against often, let's say presumptively discriminated against based on their ethnicity, to have to put a dollar amount to that moment. And my job as a mediator, right, is to talk to them about that and lean in and ask them, what is this like to mediate your dignity over a pie?
Mm-hmm.
You know, dignity is not divisible, in my opinion. It's not a divisible concept, right? So that's where you try and just lean into the parties and help them give voice, because a lot of time the advocates are not doing that to this piece. Like someone like Tanya's, Cooper, like someone like that is, but not a lot of the people we see come into our mediation rooms. What are your thoughts?
Yeah, I was thinking that I was going to talk a little bit more about this partnership, but I want to make sure that you can understand that within a mediation space, especially in a discrimination, when these types of claims come in or sort of parties come in, there are lots of tools at the mediator's disposal to resolve these cases, right? There's the tool of apology, right? Effective apologies in discrimination lawsuits really can take away a lot of the damages, right? It's like if people feel seen and for the hurt or the harm that they suffered, there's a lot of power, transformational power for that. There's also this field of restorative justice. We have Chidinma Ume, who teaches this class, which is fantastic, on sort of what does it mean, connected to apology, but what does it mean to restore and repair relationships after a significant harm has happened around us. So I want to just make sure that you understand that there's things beyond the distributive pie too that can sometimes move the distributive pie one way or another. And then, this partnership that Dean Richards mentioned, Strauss has been around for about 35 years. And, I feel really lucky that my work is really making conflict resolution accessible for underserved, disenfranchised communities through partnerships. So we have a partnership, as Dean Richards said, with the city of Los Angeles that just got executed a couple of weeks ago. We have one with the Los Angeles Police Department. We also have one with special educators within the state of California. And that's really taking these tools of basic things like listening, mediation, and really making sure that conflicts, when they start, that they can be resolved, that they don't ever reach, a lawsuit before you as law students can litigate that, right? Because that really, it makes relationships foster, right? What happens when you sue someone? Are you gonna have a relationship with them? Probably not, but with mediation, you can have the prospect of a relationship. And so thanks in large part to Dean Richards and our alumni, Capri Maddox, who's the director of the LA Department for Civil and Human Rights, if I got the acronym correctly. They are starting a discrimination enforcement provision within that office. And when cases don't rise to the level of discrimination enforcement through their department, there's still that conflict that's there. There's something that brought someone in to file a claim against someone. And so students within the Strauss program will get to mediate with a mediator, some of these cases. And I think this is the best kind of work you can do as law students, is the clinical work, is the work that really changes you as lawyers, as young lawyers. And so if you're interested in that, please come see one or both of us and we'll get you connected. It just started for that particular partnership, but even if the other partnerships are important and exciting to you, we're always looking to plug students in to what they're passionate about.
Can unless you see a hand in the room, I have a follow-up question.
Please.
And that question is, Professor Gupta mentioned the power of apology. And I'm wondering what happens, Professor Blondell, when you were speaking about like multi-partiality, pro-partiality, what happens when you're in a space where someone says, which I will say to the students, I've heard many times from clients, friends, particularly if you're a member, I think, of a historically underrepresented group, you hear from the people around you when you're the lawyer, right? So I've heard these things where they say, listen, like no amount of money is going to truly bring me justice. What I want is recognition of this thing that was done wrong, right? I think we've heard, regardless of how we feel, for example, in the field of deaths that happen at the hands of police officers, whether you believe they were instances of white supremacy or not, oftentimes those families are saying, I want someone to acknowledge that my loved one should probably still be here on earth, maybe in jail, but still be here physically in the body. What do you do when you're in a mediation and it becomes clear this is what they really want? You talked about the power of apology, Professor Gupta, where they just want someone to acknowledge what you did was wrong. It was perhaps racist, perhaps prejudiced, perhaps homophobic or transphobic, and they want to hear those words said. And the other party is maybe because there is such a moral implication to acknowledging when actions veer into those areas, are resistant to that. I don't know if that question is making sense, but it's one that I think we've all think about because there is a moral weight. And since we're plugging things, I'll give my own plug for my class or Professor Cooper's class on race and the law, or Professor Goodman's racial justice, I think, or my discrimination. I'm sorry, diversity and inclusion seminar, but all of us in some way talk about sort of the moral implications, right? And that in some ways it's worse in our society to be called a racist or to be called homophobic or transphobic or sexist than to actually do the things. So when someone is saying, I want an apology, and they feel like, well, that's worse, what do you do? How do you get to that point?
It's such a good question, isn't it? I'll go first. So first of all, I just want to tell you, this is one area of a lot of research. So I'm so glad you're asking about it. There are many things in the law that have legislated our integrity out of what we can do in a lawsuit, right? An apology is one of them, because it can be admission against interest. So a lot of people are afraid to apologize, okay? In fact, I think there's 13 states that have apology privileges in certain contexts, usually med mal, okay? So when someone's been injured in a hospital setting, the doctor can say they're sorry, and a lot of those settlements are much lower. So the connection between apology and settlement number, there has been quite a bit of study in med mal and other areas, the number's lower. In the area of race, I have to tell you, I have a practice of public sector, so not a lot of money, pro se often discrimination cases where there is this need for the apology. Before I talk about when someone's resistant, I'm going to talk about when someone's not resistant. I'd say in those cases, 80% of them have an apology. Most commercial mediators, if you ask them what percentage of cases do you have that have an apology, they're going to say around 10%. So I think it has something to do probably also with the way where I'm going as a mediator and what I do. But a lot of them do have the apology. So people often, when given the privilege or confidentiality, we call it confidentiality in California, most other states, it's a privilege. When given the privacy to be a human being, I see a lot of humanity happening. And this is why I love mediation. And legislatures have said, just like priest penitent, just like husband wife or partner or just like therapist and patient or doctor patient, that relationship is so important that we're going to allow people to say what they need to settle. So that's my first just plug. We have a great colleague. When people don't want to apologize, Dean Richards, usually what I'm talking to them about is one of those things. I'm talking to them about the myth of this goes somewhere else. My experience in police officer cases, when they understand how airtight the privilege or confidentiality is, that opportunity to be a human being and reflect on the injury that's happened with someone else in the room, when we can help separate it out in a communication structure from, this is not about whether this was in compliance or policy. This is about a different type of apology in terms of how you're treating each other as human beings and what's happened since the injury until now and how you haven't been able to talk and the re-injury that's happened over and over again because of your inability, because of the legal system that pulls people apart and doesn't allow them to have that redemptive moment, right? That injury, if nothing else, they can often talk about that piece. You know, so there's usually a piece that we work with people on to figure out what part of the apology is comfortable. Studies show that a partial apology is more dangerous than no apology though. So we have 4 elements of a good apology, we coach them, we go through those 4 elements of a good apology, and we make sure that there is not any partial accountability piece in any piece of that. It's often very heavily coached. And I'll just stop talking since I'm talking too much, but I'm sorry, I love the apology. It's just like such a great moment.
Yeah, I have nothing more to add to that, but I will say we've all been recipients of bad apologies, right? And you know, when you start out and you're sort of cross-examining someone, you can be like, I'm really sorry for what happened to you, or something like, you know, something that is not meaningful in any sort of way. And that's what Professor Blondell was saying is when we do the coaching, it really has to be a transformational apology to land in the way that you want it to be. It needs to acknowledge the harm. It needs to show the sentiments that you feel, and then it needs to then have a sort of a repair element to it that, you know, that you will not do this again, or that this is what the process has taught you, or this is what your commitment is. And so without these elements, it's an apology that we've gotten from our spouse, when, you know, at least I've gotten from my spouse, I'm sorry to do the dishes, I'm like, fine. You know, it's not a meaningful apology. And I think that that's really what allows the settlement numbers to go down.
Yeah. So we have about 2 minutes left. I want to ask you this final question. For this year, our Office of Diversity and Belonging theme is a community of light makers. And I'm wondering for each of you, what does it mean for you to be a light maker in the field of ADR, particularly around race issues of race, sexuality, social justice generally? Keep in mind, students have to go to class, so
Okay,
quick.
I will, she's pointing me to go first, I'm gonna give you 30 seconds. Listen, the role of the lawyer that I have chosen is a scam. I get to be in the place that people are at when it's over, when it's done, when they say they're sorry sometimes, or when they have finally made the decision about what their outcome is gonna be, their self-determination. It is so touching, it is so moving, I call it the greatest show on earth. And why wouldn't you want to be a part of people's best selves? When we're in conflict, we're other realized. On that day, you help shift into them making a good risk management decision about their own lives and hopefully a restorative and healing one. Why wouldn't you want to be a part of them being their best selves after they've had 5 years probably of being mired and ill from the stress of a lawsuit? Lawsuits incredibly stressful. So yeah, that's the light we're looking for, the light at the end of the tunnel. There's so many other lights, aren't there?
There really are. I was just gonna say, you know, when you think about light, you know, Diwali just passed. It's the festival of lights for Hindus around the world. And there's a sense of each of us carries a light within us, right? And so when I think about ADR, light to me connotes awareness. And I think, you know, I'm a lawyer first, right? And we went to law school and you're taught to think in a very adversarial way. But if you can have and carry that awareness with you and not typecast yourself in a box, but really think broadly about who you are as an advocate, as an ally at times, right? Within sort of ethical boundaries, that awareness will get you so far in whatever path that or journey that you're seeking, whether it's to be a lawyer or to be a mediator.
Well, thank you both so much. I'm sure those in the room were just as educated, edified, and encouraged as I am today. And thank you for your generosity of time and wisdom with us. I hope you all have a wonderful rest of your day. Enjoy your classes.
Thank you.
One last plug, November, sorry, not to steal the stage, Dean Richards, but November 11th, this Friday, Strauss Institute is having a fantastic international conference. If you haven't registered, please come. We're going to be looking at mediation and diplomacy on a global